But now I'd like to hear from additional witnesses who are here today, and I want to introduce Pat Crank. He is joining us from Thermopolis today. He is from Cheyenne, Wyoming, and spent a long time in Casper as well. He is a senior partner with Crank Legal Group in Cheyenne. He has been a commissioner on the Wyoming Game and Fish Commission since 2014. He's also served as Wyoming Attorney General from 2002 to 2007 under then Democrat Governor Dave Friedenthal. So I'm so happy to have him joining us today. He received both his undergraduate degree and his law degree from the University of Wyoming. It's a privilege to welcome such a distinguished witness as Mr. Crank before the Environment and Public Works Committee today. Pat, thanks so much for joining us from Thermopolis, and I understand that a Game and Fish meeting is occurring there today, for which you're attending and have stepped out of the meeting to join us at this hearing.
Thank you. Good morning. May it please Chairman Barrasso, Ranking Member Carper, members of the Senate Environment and Public Works Committee, and Senator Enzi. Thank you for the opportunity to offer my perspective today on the stunning and amazing recovery of the Yellowstone grizzly bears, the significant failures that have occurred with regard to judicial review of delisting decisions made by the Fish and Wildlife Service, the significant erosion of public support that occurs when a species has been recovered and then the courts block the removal of that species from the endangered species list, and to offer my support for Senate Bill 614. My testimony is based on having served on the Game and Fish Commission for approximately 5.5 years. It's based on my experience as the Wyoming Attorney General for 5+ years. It's based on my experience as a lifetime sportsman and lifetime resident of Wyoming and 35 years of legal practice. The grizzly bears, in 1972, we had approximately 100 bears left in the greater Yellowstone ecosystem. By 2020, we have a very conservative estimate of at least 700 to 800 bears. I think you would be hard-pressed to find any scientist involved with the grizzly bear recovery that would disagree with the statement that we likely have 1,000 to 1,200 bears in the greater Yellowstone ecosystem. We know more about this species than any other species of wildlife on the face of the earth. They have been intimately and exquisitely studied since being placed on the endangered species list in the 70s. The world's best large carnivore biologists have studied and managed and recovered this species, and it's an amazing success story under the ESA. This year in Wyoming, we surpassed the 1,000th bear that we have captured and fitted with radio telemetry equipment. We are closely, well, in the very near future, we will have over 1 million GPS monitor coordinates from grizzly bears that are collared with GPS monitor collars. In one 2.5-hour flight in 2020, our personnel observed 82 grizzly bears. As of 2019, grizzly bears occupy over 42,000 square miles. That's an area larger than the state of West Virginia. As of 2020, grizzly bears occupy virtually every square inch of suitable habitat in the greater Yellowstone ecosystem. Grizzly bears have exceeded all federally mandate and biologically determined recovery criteria since at least 2003, and in reality, clear back to 1997, as mentioned by Chairman Barrasso. The ESA is an amazing piece of legislation, and it's resulted in this incredible success story where we recovered an iconic and amazing wildlife species to levels far surpassing recovery criteria. The premise of the ESA is quite simple. If an animal is suffering They're placed on the Endangered Species Act list, given federal protection, and then state and federal wildlife managers study that species, figure out what makes them tick, what they need to survive, and what recovery criteria should be set to ensure they remain in the environment for the foreseeable future. Once that species reaches recovery, the federal and state wildlife experts via the Fish and Wildlife Service and the delisting process propose a rule delisting the species and setting forth what will occur, what state management will occur. Those are written plans, they're quite precise, and the species should then be removed from the list. After that, state wildlife managers, who are truly the experts on managing these species, because they're the ones that day in and day out do the work to recover the species, understand the species, and ensure they exist in perpetuity. Environmental groups, unfortunately, file endless lawsuits to prevent delisting at all costs. The Yellowstone grizzly bears are a great example. No one can argue that we've met recovery criteria, that we have a robust population of grizzly bears, that this species will exist for the foreseeable future under state management. These lawsuits that they file generate millions of dollars in contributions and membership contributions. Everyone, environmentalists, hunters, fishermen, sportsmen, are passionate about wildlife. And that passion, combined with frequent misinformation regarding what will happen once a species is removed from the endangered species list, generate millions of dollars of revenue for environmental groups. And then if they are successful in Endangered Species Act litigation, all their attorney's fees get paid. I've been informed that with regard to the most recent action with regard to the 2017 delisting rule, which was struck down by a judge in Montana, the environmental groups have already requested over $1.4 million in attorney's fees with regard to that litigation. The tragic thing is, under the Endangered Species Act, environmental groups can forum shop and pick the judge that they believe will be most likely to strike down a delisting rule. I've been a litigator, and I spend the bulk of my time doing personal injury cases. I would love to be able to select the judge that will hear my client's case. Under the Endangered Species Act, environmental groups get to forum shop, pick the judge that they think will be most likely to be politically and biased in their favor and strike down the rule. These judges and courts, unfortunately, in, I believe, direct violation of the Endangered Species Act, ignore the findings of the experts. Those experts within Fish and Wildlife Service, within state wildlife management agencies, and the judges substitute their political decisions with regard to delisting proposals for the actual experts who understand, and in the case of Yellowstone grizzlies, have managed and recovered this species for over the last 50 years.
Since we have another witness to testify, and we want to have time for questions, Pat, I don't know if you can just very quickly make any final statement, then we need to get to our third witness and then have time for questions.
Thank you, Mr. Chairman. I would just sum up that failure to remove a species once it's been recovered seriously erodes public support for that species. And it's a tragedy with regard to this species that endless litigation and federal courts substituting their political and uneducated judgment for the scientists have prevented state wildlife biologists and experts from managing grizzly bears in the state of Wyoming, Montana, and Idaho. Thank you.
Thank you, and we'll be back with questions in a moment. We're going to